Good morning, everyone. Welcome to our information session on student visa cancellations and refusals. This is an information session presented by GPS Lawyers and Consultants. I am the founder and principal solicitor at GPS Lawyers and Consultants. Today we have with us Mr. Harry Grossman, who is our senior consultant and immigration law specialist. Welcome, Harry.
Thank you, Apurva.
Thank you, Harry. We can't wait to hear more about your experience in this area, and then also give knowledge and information to students who are either facing student visa cancellations or are filing their visas, so that we can guide them and navigate them through this process.
Certainly. Thank you again, Apurva.
Thank you, Harry. Can I please, before we begin, can I please request you to introduce yourself?
Certainly. I'm an immigration law specialist, accredited by the Law Institute of Victoria since 1992, and I've had a long career in migration law, some 35 years. And as you can well imagine, over the span of those years, I've assisted many students facing either student visa refusal or student visa cancellations. And it'll be my pleasure this morning, by way of an informal session, to assist those who may be at the cusp of just this very predicament, either a visa refusal or a visa cancellation.
Thank you, Harry. Today, what are some of the biggest mistakes or misconceptions that international students have about their visa rights and obligations in terms of their student visas in Australia?
Yes, in my experience, the single biggest problem that students face is a failure to read the basic student visa conditions that attach to their student visa. By which I mean in particular condition 8202, which seems quite innocuous on the face of it, but it requires, by way of an ongoing obligation, that students maintain enrolment in a registered course, maintain attendance at that course, and also, of course, achieve satisfactory progress as defined by their education providers. Students sometimes do not understand, coming of course from an international background, that in Australia we have a whole of government approach. And the Department of Home Affairs that grants visas also receives, if you like, progress reports from education providers and from other sources as well, to indicate whether or not a student is indeed satisfying condition 8202. So to summarise, the mere obtaining of a student visa is not enough. One has an ongoing obligation to abide by student visa conditions.
And would you say, Harry, that not abiding by the student visa conditions is or could be one of the biggest mistakes that students could do, and that could put their visas at risk? And would there be any other conditions that could put their visas at risk?
Yes, certainly. Students should be familiar with their work limitation condition and not to exceed the 40 hours per fortnight, and should be aware that, again, due to a whole of government approach, the department has access to employment records and has access to a range of information about whether or not, for example, a student may have chosen to form their own company and be employed by their company on a full-time basis. These are the sorts of issues that arise in practice.
Would you say that a minor traffic offence or legal issue really could be a legal issue that's related to the visa cancellation? Like we've seen in Puddasani decision of the tribunal earlier this year?
Most definitely. The department has a number of levers that can be pulled, and one of those is if a student has committed an offence against the state. Pitasani was an interesting case in that regard. I'm glad you've jogged my memory, Apurva. In that particular case, the student was found to have exceeded the speed limit by approximately 50 kilometres per hour. And as a result of that, the student faced visa cancellation. Fortunately, at the tribunal level, because the student visa had in fact been cancelled, the tribunal sought to take a broader approach and considered that Mr. Pitasani was in fact a genuine student, having regard to their visa history, their education history, and in all other respects was compliant, and therefore chose in its discretion not to affirm the decision to cancel the visa, which really meant, of course, that that student visa was saved. But the short answer is that any infringement on the law can, at least in theory and perhaps even in practice, lead to student visa cancellation. Certainly. In fact, that came about because of a direction by the Minister for Home Affairs, and that direction is known as Direction number 106. And departmental officers are now required to assess whether or not a student or a person applying to become an international student really is a genuine student or not. In the past, it was all about whether they intended to leave Australia at the end of their student days and go back to their home country and utilise the skills they'd acquired. But there's an increased recognition that students may wish to use their qualifications to gain further stay in Australia and indeed even permanent residence. And that is certainly not an offence at all. But the idea is to understand that in applying for a student visa, or indeed in seeking to maintain their student visa, they must show a requirement of genuine entry. In summary, what that really means is that the person must show that their primary interest in coming to or remaining in Australia is to study, and not to use the student visa as a sort of backdoor method of gaining de facto long stay residence in Australia.
We've seen cases where students lost their visas because someone else, like an agent, submitted dodgy documents.
Yes.
So, what can students do to protect themselves apart from coming to us?
Ideally, they would come to a reputable migration agent or a reputable migration lawyer. But if they find themselves in a situation where, sadly, in retrospect, they've discovered that the migration consultant has lodged fraudulent documentation or information, you probably don't need me to tell you that such students are in terrible trouble. They need to mitigate the damage done by such migration agents or consultants by notifying the department, and there is provision by way of forms that can be lodged to inform the department that certain information or documents were given without their knowledge and certainly against their consent, that those documents or that information is incorrect, and to seek to correct the
What actually happens is the student visa is cancelled.
Yes.
So, is that it? Or are there any other avenues that students have, any other options that students have apart from the visa hopping options?
Well, certainly if they face student visa cancellation, any bridging visa that attaches to any new application would also be cancelled. So what they must do if they want to remain in Australia is to seek to apply to the Administrative Review Tribunal to have the decision cancelling their visa overturned. And it's recommended that they should seek legal advice immediately, because there are very strict timelines for lodging such review applications, and those timelines cannot be extended. The tribunal has no discretion to extend those timelines. Generally speaking, one should lodge a review application within 14 days.
Thank you, Harry. Now, based on your experience of having dealt with visa cancellations multiple times and also being a former member of the AAT, now ART, do you have, or what are those tips that you would like to share with students that would help them win their case? Can we have 5 tips from you, Harry, please?
Most certainly. First and foremost, there needs to be a proper submission by the student as to why it is that they claim that the visa was cancelled inappropriately.
Thank you. And the second one?
The second is they should attach to such submissions any documentation that would assist their case. For example, if the visa was cancelled because the provider had provided information to the department that the student had failed to meet satisfactory progress, the student may wish to attach to their submission medical documentation indicating that they had good reason why they were not able to attend their course at a particular time, or any other extenuating circumstance such as illness in the family, a crisis, whatever that may be, that needs to be directed to the attention of the tribunal.
Sure. And the third one?
The third point is to challenge even the notion that they failed to attend and to seek to have the record corrected as to their attendance. If they can prove by independent means that they have attended their course, or if they can obtain under FOI records from the provider to show they have indeed attended their course and the provider has incorrectly recorded that they had not attended their course, that needs to be provided as well.
Right. And the fourth one?
The fourth one is to provide reasons other than related to the actual cancellation as to why it is that they should not have their visa cancelled. The tribunal has discretion to be able to look into all of the circumstances of the individual. For example, that they have in the past always met their student visa requirements is one. Another is that they have good reason to return to their home country on completion of studies because they have mapped out a career future and they have even identified an employer in their home country who will be able to employ them immediately on their return. A third might be, for example, that they will be the main supporter of their family in their home country and therefore should be allowed to complete their course to achieve that end.
Thank you, Harry. And I think I know what the fifth one is. Get good legal representation. And you know who to go to, Harry.
And to make those submissions as soon as possible.
Yes.
The more comprehensive those submissions and the earlier they are presented to the tribunal, the greater is one's prospect for success at the tribunal.
Talking about the legal representation, Harry, when should someone seek legal help? Is it only after the cancellation or much earlier?
One should seek advice from an accredited law specialist, if possible, in immigration, or at the very least a senior practitioner, as soon as possible after receiving an intention to cancel one's visa. However, even before then, one should be appraised of their student visa conditions, and if one is tempted to embark upon some course of employment or self-employment while studying, perhaps seek counsel from their migration lawyers prior to embarking on any such intended endeavour, because it is very important not to provide any source of reason for a student.
What is your one and most important piece of advice for students facing visa cancellations?
They should seek immediate legal advice, because attempting to answer the department on their own can unfortunately cause even further problems for them. For example, if in an unguided interview with a departmental officer, they make admissions that their main reason for coming to Australia or remaining in Australia is to work or to care for some local relative, that will not bode well. So the best piece of advice is not to engage with the department on their own, but to immediately seek legal advice from someone very experienced in this particular field.
Thank you, Harry. In order to reach us and seek legal advice, you can email us at info@gpslawyers.com.au, or you can call us on the number that you'll see on the screen next. We will look after you, and we will make sure that you achieve those dreams with which you came to Australia in the first place. All the best to you. Thank you. Thank you, Harry,
Thank
for
you,
your time.
Apurva, for the opportunity.